afternoon, Your Honors. Joanne G. Haas-Swanson, appearing on behalf of Dr. Castro and his professional corporation. I would like to reserve 2 minutes for rebuttal. However, I'm happy to answer any questions you may have and waive the 2-minute free fire zone. The question that this court has asked us to address is whether the filing of a motion for extension of time to file an affidavit of merit, which is subsequently granted, is sufficient to toll the statute of limitations. And respectfully, the answer to that question is no. This statute is not ambiguous. It allows the trial court to extend the time for filing an affidavit of merit for 28 days if good cause is shown. As the court explained, the Court of Appeals explained in the published Bartlett opinion about 15 years ago, the extension is not automatic. It requires the exercise of discretion by the court by virtue of the permissive may as well as the conditional good cause language. So until the trial court exercises its discretion, the statute of limitations continues to run. There are no words in the language of this statute that effectuates tolling upon the filing of a motion to extend. And of course, this court cannot read those words into the statute. This court has consistently given a strict construction to the affidavit of merit provision and to other provisions in the tort reform legislation that was enacted nearly 3 decades ago. So if the statute of limitations expires before the court enters an order granting the requested extension, the issue has been decided by the march of time. This means that in order to be effective, a motion that is filed under subsection 2 must be filed sufficiently in advance of the expiration of the statute of limitations.
So, counsel, under your argument, it really comes down to, in a lot of ways, the scheduling clerk for the court.
Not really, Your Honor. I am in agreement with Judge Wilder's dissent that there are actions that we can take to get an expedited decision on an emergency motion, and we have all had occasion, many of us have had occasion to do it throughout our careers. We're not. But
it really is up to that scheduling clerk to make sure that happens in that time period.
Well, if you don't get a result from the scheduling clerk on the day that you're filing your motion and seeking a decision, you can go to the chief judge of the court. You can file an emergency motion in the Court of Appeals. I mean, there are means you can take. But I don't think the purpose of this...
Not necessarily effective ones.
Pardon?
Not necessarily effective ones. I mean, you can do all those things, but depending on the court, unlikely to move the needle very much.
Yeah, they might work, they might not. I mean, you know some judges where you can't get anything to happen.
It might work and it might not, but I guess that the underlying question and premise...
And if it might not, then you just...
Oh, well.
Oh, well?
It assumes, Your Honors, that this statute is designed in order to assist someone who has procrastinated until the very last day in order to be able to bring their claim. I don't view this statute as being designed to assist procrastinators.
What work does Section 2 do in this regime?
What does it do if it does?
Why do you have it if it has no effect on how this process works?
I don't think that this is designed necessarily. It says nothing about the statute of limitations and tolling. I think it's designed.
What role
it plays.
Obviously, the legislature first intended that the AOM be filed with the complaint, but they said, okay, it doesn't have to be. You file a motion. What were they trying to accomplish here, do you think?
I think they were trying to accomplish a little flexibility in the scheduling. That doesn't mean that they have determined that they're going to extend the statute of limitations. Not all lawyers...
If I have time in my statute of limitations and I don't have the AOM yet, why wouldn't I just delay filing the complaint? Because
not all lawyers want to delay. They might want to get their case started. They might want to begin with discovery and other things. I don't think it's necessarily meant to be a lifeline when you're up against the wall on the statute of limitations, which, by the way, was not factually the case in this particular instance. The reason I say that...
What's not factually the case?
Pardon?
You said something wasn't factual.
It wasn't a sense of urgency. This wasn't a last minute going to the lawyer and the lawyer not having time. The expert witness who ultimately signed the affidavit had been contacted 4 months before. Not by this lawyer, but by another lawyer he had been, or someone else, he couldn't identify who it was, and had said, yes, he'll review it, but was never sent the records. Also, in this particular case, there was a threat.
But maybe that sounds like maybe reasons why a judge might have decided not to grant the motion. Maybe you'd say, well, that's not good cause. This
Right.
judge disagreed. But
Right.
I don't know how that goes to the reading of the
Well,
statute.
let me just ask you to consider the statutes in other states that do, under the same requirement of filing, they call it a certificate of a merit or something, used a little different language, but those statutes expressly either automatically toll the statute of limitations by simply submitting to the clerk of the court your request, and then you get in Connecticut, it's an automatic 60-day extension.
But that's not even in Section 1. The only way that tolling occurs is in the natural course by the filing of a complaint. In this regime, the additional requirement of filing an affidavit of merit is required, and then but the statute then says you can have some extra time. So I'm trying to figure out if it's all a matter of nothing, if you have to file the AOM and the complaint together and you have time, you never get to use the 28 days. I can't understand when it becomes functional in your world.
It doesn't have to be functional only in terms of the statute of limitations, is how I view this. Because if you look at the statutes that do provide a tolling of the statute of limitations when additional time is required, those words appear in the statute. They expressly toll the statute of limitations, and they expressly provide for interim tolling while the court decides in the instances where the court is going to decide.
But your view is that the two contingencies in this statute, the may authorization and the for good cause shown, should draw our attention away from the filing of the motion to the court's decision.
That's correct.
Because that decision will not come until the court has overcome both of those barriers.
That's correct. And if that decision comes after the statute of limitations has expired, because it doesn't happen automatically upon the filing of the motion, under what circumstance does a judge have the ability to retroactively toll a claim that has already expired, or worse, to retroactively revive a claim that has been barred? And I want to just make the point.
But it's retroactive only because, according to you, our focus should be on the judge's decision, not on the motion itself.
That's correct.
Because of those contingencies.
That's
That's what
correct.
makes it retroactive.
That's correct. And the court could very well decide that good cause doesn't exist.
And then you're just...
And then you're out of luck.
Then you're out of luck. If
So
you've
that's-
waited...
then you win.
But in our system of jurisprudence, under what circumstance does a court, by issuing an order, have the power to revive a claim that has been barred by the statute of limitations, or to retroactively toll a claim? Our legislature knows how to revive claims when that's the intent, and it knows how to toll claims. We all are familiar with the notice of intent statute. Medical malpractice plaintiff has to give notice, and during the period of notice, if the claim is going to be barred by the statute of limitations, the statute of limitations is tolled. That's expressed in the statute. The legislature has also enacted statutes that revive claims when it wants to do so. For example,
Let me just jump in. Isn't some of this difficulty caused by our holding in Scarcella, that the statute is only told upon the filing of the complaint and the affidavit of merit? Because without that, if that holding is wrong, all of these provisions start to make a little more sense, don't they? So for example, you look at subsection 3 of the statute, and it says if the defendant fails to allow access to medical records, then the affidavit may be filed within 91 days after the filing of the complaint. So can the statute run in between the filing of the complaint and that 91 days?
I would say no, Your Honor. Well, that's a
We
little...
don't have the tolling language there, and we don't have
There's
it's
no
revived
statute,
and all this other
there's
stuff.
no indication anywhere in this statute that the legislature was addressing the statute of limitations, was thinking about reviving a barred claim or tolling. When the legislature wants to do that, it knows
No,
how.
I agree with you, but I'm having some difficulty, because when I look at subsection 2, and it says, upon motion of party for good cause shown, the court in which the complaint is filed may grant the plaintiff, so on and so forth, which seems to suggest that the affidavit can be filed after the complaint has been filed, 28 days later. Your position is the statute's only told when the complaint and the affidavit are together, right? Because if the complaint told...
Not together, but within the statute of limitations, before the statute of limitations expires. That's what the case law says.
But if the complaint told the limitations period, we wouldn't have any of these difficulties, right?
If the complaint
Told
told...
the
complaint alone.
like it does in every other...
If the complaint
like it-
told, it wouldn't be a problem. But
Like
in
it
this,
does in every other type of case, right, other than
Right.
med-mal cases, according to Scarcella.
Correct. Correct. What I sense is this court being a bit troubled that maybe this statute does not do what you think it should do or what you think the legislature intended it to do. And I caution you, don't go there, because you have told us many times we cannot put words into the statute to make it better, to make it do what we think it should do, to make it more effective, to accomplish a certain result. That's not your job. That's the legislature's job. And if the legislature did not get the horse across the line, the legislature can fix it. Scarcella and the whole body of law that has followed Scarcella has been in effect for a very long time now, at least 15 years, starting with Holmes and beyond. And I think that you have to enforce the words of the statute as they exist.
Is it your position that the only way a legislature can toll a statute or revive a barred claim is by using explicit language? The statute is hereby tolled, or this claim is hereby revived? Because I'm struggling to figure out what the default rule is. Should we assume that if they say nothing, then the statute continues to run and it can never be revived?
Well, we do have rules of statutory construction that this court has cited many times that says when the legislature uses language to achieve this result in one instance and uses different language in another instance, you don't assume that the same result was intended. We have to go by the words of the legislature. And all the legislature did in this case was say that there are instances when you don't have to file the affidavit of merit with the complaint. But it doesn't say anything about tolling, and it doesn't say anything about retroactive revival of a barred claim. And so unless we're going to disregard the statute of limitations and the whole body of law that governs that, we have to abide by the words of the statute. And we also recognize, many of us on the defense side, bring motions for summary disposition based upon the expiration of the statute of limitations. Is our courts now going to have the ability to say, no, we're going to, you're not prejudiced, or have are we going to start making up ways that the courts can now undermine the statute of limitations, can extend it, can revive a barred claim? What I wanted to point out is that the legislature has done that. In the Paternity Act, an amendment to the Paternity Act in 1986 changed the statute of limitations from 6 years to 18 years. And in that statute, the legislature expressly stated, expressly stated that this amendment applies regardless of whether the cause of action was barred under this subsection before June 1, 1986. There's another one, and that is MCL Well, I can give you, that one is cited in every.
What is your point? Has this court looked at any of the?
I'm sorry?
I don't understand what your point is in citing those. Has this court looked at any of those statutes?
My point is that when the legislature wants to revive a barred claim, it knows how to do that. It uses specific language that retroactively revives the claim, as it did in the Paternity Act, as it did in MCL 5866, which is a provision that has a means of reviving express implied contract claim that's been barred. And so we can't assume, just by the virtue of the language that exists in subsection 2, which does not do that, that it should have that same effect. That's my point.
Well, I also don't think we can assume by you reading those statutes that those statutes are appropriate ways of doing what you say they suggest, what they stand for.
I guess it depends upon whether you accord the legislature the right to revive retroactive claims. I mean, I'm talking about the language that exists in the statute. I haven't done any research on them. I haven't had personal experience with them.
Well, let me ask you about de Villers. Justice Larson was asking what the significance of silence is, and I wonder about that too. In de Villers in 2005, we held that we lack the authority to read into a statute a tolling rule that is not itself found in the statute. Now, if that's talking about circumstances in which a tolling rule is not explicit, it's just kind of a tautological statement. On the other hand, if it's focused upon finding language concerning tolling in a statute before we're going to find tolling, that would seem to support your argument, would it not?
It would seem.
What does de Villers stand for? Have you looked at that case?
I haven't, Your Honor. I apologize. I would be happy to review it and to submit a follow-up brief if you would like.
It's a very distinguished opinion.
Pardon? I'm sorry?
He's teasing me.
Okay.
He said it was a very distinguished opinion.
You must be the author then.
No.
Wrong guess.
Okay. Thank you.
James D. Wines for the plaintiffs and appellees in this court, and this is strict statutory interpretation case, and it's nothing more than that. When you look at the statute 600.2912D, it specifically starts out by saying 1 is subject to section 2. It says that right there. 1 talks about filing the complaint with the affidavit of merit. That's wonderful if you can get it in time, and especially when the court's in Washtenaw County. And I need not tell you what else is in Washtenaw County, but it's very difficult to get any doctor to go against another doctor in Washtenaw County. That's why we had to go out of state. But section 2 thereof says, upon the motion of a party for a good cause shown in the court in which the complaint is filed. It doesn't say may be filed, will be filed, could be filed. It says is filed. What could be clearer? Right there it says I can file the complaint within the 2-year statute without the affidavit of merit. Providing that, of course, we get the order of the court and so on and so forth. I am the only person that I'm aware of that read this statute and put in there that subject to, that completed all the requirements within the 28 days. Getting the motion heard, the order in our favor, the affidavit of merit, all of that within the 28 days. That can't be held against me. Now, if we look at all the other cases, what happened? Oh, I didn't file it, and I forgot it was in my briefcase. Files it a month later, the affidavit of merit. Never brought a motion until a year later. Didn't even read the statute. Apparently, I feel sorry for the clients. But it is strict interpretation. I'm not asking you to do anything different than what the statute says. And when it says complaint is filed, obviously it says what it means. I filed that complaint. I filed it with a motion. But then I proceeded to perform within that 28 days. That's as simple as it gets. And I don't think I need to go further, quite honestly. And I think that's why a majority opinion of the Court of Appeals was cited at 312 Mishap 1, because I'm the only one I've ever seen that did comply with everything within 28 days. Not, patting myself on the back, but it appears to be true from what I've read and researched.
You didn't come to Lansing to get your physician.
Yes, I tried Lansing,
Oh, okay, I thought there might be a little.
but he had a background with
interim
Ann Arbor.
rivalry.
He had a background with Ann Arbor.
Should have gone to East Lansing.
I meant instance.
I should have gone to my alma mater, Purdue, but I should have gone to Purdue, but the problem is we only have the veterinarian school in Indiana. IU has a medical school. So I don't think a veterinarian certificate would be much good.
Well, they're very.
Although it might be better. Do you have any questions? Thank you very much.
Thank you.